Okay, Assalamualaikum warahmatullahi wabarakatuh once again. So the topic for today is undue influence. So this is the second topic for law 1311. Okay, law of contract 2, undue influence. And we have completed the discussion on coercion, which is one of the vitiating factors which might affect a valid contract. So now another factor which we are going to focus on is undue influence. Okay, it has two words here, undue and influence. So we are looking at the definition after this. Okay, but before that, let's have a look at the outline of our discussion. So as compared to the earlier topic, which is slightly shorter, quite short. So this topic is slightly longer. I mean, it's quite long, basically, the topic, because we have longer provision and we have a long list of cases to be discussed together. Okay, as usual, we'll start with after this. Okay, right after this, we are going to start with the definition, which covers both general, okay, as well as statutory definition, specifically under section 16, Context Act 1915. And then after that, we are going to have a look at the classification. And this is based on common law approach, because under section 16, there's nothing about which give hints or which discuss about classification or categories of undue influence. So basically, there are two classes, okay, or two types of undue influence, which is actual, and another one is presumed undue influence. And then we are looking closer, okay, looking deeper at section 16, subsection 2. Okay, we are looking at the elements. So we are going to identify, we are going to have some, we are going to ask students to identify the keywords under section 16. And then after that, we are going to see all the elements, okay, dominant position, real opponent authority. This is all taken from section 16, subsection 2, okay, fiduciary, mental incapacity, and unfair advantage. And then another subtopic that we are going to look after that is presumption of undue influence. And the next thing is shifting the burden of proof. And then the next stage is rebutting the presumption. And then a little bit on constructive notice, which is very limited discussion. And the last part of the topic will be effects and remedies. What happened to the contract, which is being affected by undue influence. And then on with regards to remedies, okay, there's a slightly long discussion here, longer discussion here, exceptions to rescission, because a rescission is one of the remedies, okay, for the contract being affected by undue influence. Okay, let's go to the general, and then let's go after that, we are going to look at statutory definition. So we'll start with general definition, literal meaning. Okay, literal meaning. What's the meaning here? What's the meaning of the word? When we have, when you see the word undue, okay, undue, it means what here? Undue, usually it relates or it means or it denotes improper, something which is not supposed to be there, okay, which is not supposed to happen. And influence is pressure. Okay, both the things here, they are actually invisible, okay, but you can feel it, but you cannot really tell, oh, is this the real influence of pressure? Okay, something which you cannot touch, but you can feel it, okay? So undue influence, it refers to improper pressure, okay, on whom? On a person, okay, usually the person is the claimant, the plaintiff. So what happened next? Resulting in his being, okay, at a manifest disadvantage. So because of this improper pressure, so he suffers from manifest disadvantage. With regards to what? In relation to some transactions. So it must have as there, okay, some transactions. Or another way of defining, and now we are more focused. Okay, the first one is quite general. Okay, another way of defining the word, general meaning here. So undue influence, it refers to domination. Okay, that's the word, domination of one party over the mind of another. Mean that here the party really, both of them, they don't stand on equal footing. That's why one of them can dominate the other one. Okay. All right. To such a degree as to deprive. So what's the effect? To deprive the latter, to deprive the weaker one, to deprive the victim, okay, of the will, okay, of his will to make an independent decision. So the moment he decided to enter into the contract, the decision is no longer independent. It is independent because of this undue influence, because of this improper pressure. Okay, I want to show you section 16, okay, but I think I have to stop share and then reshare, kan? Otherwise, if I just jump to the next window, you cannot see it. Okay, show So it's a long way. Here I go. It's always problem. Hold on, huh? Oh, I stopped sharing. All right, that's it. Okay, I'm sharing another screen to show to you the Contracts Act. Okay, so this is Contracts Act. We have completed discussion on section 15, okay, on caution, which is quite short, kan? Okay, the provision, if you notice, it is quite short, okay, the main content here, but it contains an explanation as well as illustration. So now we are looking at the next section, which is undue influence, which is contained in section 16, okay? In section 16 alone, it has, if you notice here, okay, let me make it bigger. All right. So here you have subsection 1. Okay, we're going to read together after this. And we have subsection 2. Okay, section 2 here. And it has clause A and B. So you can see it's very long. It's quite long. And then it has subsection 3. And it contains clause A and B as well. And it has illustrations, okay, A, B, C, D, to give you an example of in what way undue influence may take place. Okay. Okay, let's read section 16 here. Okay, I'm reading it to you. So a contract is said to be induced, okay, induced by undue influence, okay, where the relations subsisting between the parties, okay, are such that one of the parties is in a position to dominate the will of the other. So this is the statutory definition, okay, and you mean that here after that what happened? And uses, okay, that position. Okay, the one who dominates uses that position to do what? To get what? To obtain an unfair advantage over the other, over the one who is being dominated. Actually, section 16.1 here, we read together with section 14. Okay, here 14B. Okay, because for caution is 14A. So undue influence 14 subsection, clause B here. Okay, you can also use the word subsection B. Okay, that's the statutory definition. So we go back to our slide. Sorry, I have to keep on stop share and reshare. Okay, we were there. I mean, we were here. All right. So I have shown to you just now section 14, subsection B, clause B, and also the main content of section 16. So now you have to identify some of the keywords. Okay, usually if we read a long section, okay, we have to identify the keywords because all other words, they are just supporting words or the connecting words. So now we want to know the keywords in section 16. So we have to go back to section 16 again. Sorry for this. Okay, we go to section 16 again. Okay, what are the keywords? Now I can call names in section 16. Okay, 16, subsection 1 only. Here, from here until here, from the word a contract and then until the word the other. So there are few keywords that we can extract from this particular section. Okay, let me call name. Who wants to start? I mean, what's the first keyword from this particular section? Secret video. Okay. Can we have? Yes. Anyone? You can unmute and then you can try. What's the answer? Nudini.
Relation. Yeah. Is it dominate? It's the first keyword.
The first one. Try to find the first one. You don't jump. Okay. We identify one by one. The first one.
Parties.
Which one? No. Before that.
Is the first keyword induced and or undue influence?
No, that one is still not really the keywords. Okay, that one all the explanation actually.
I think it is relation.
Yeah, correct. Thanks, Christina. Okay, the first keyword here, relations. Mean that here, in order to prove undue influence, there must be relations. The party must be related. Okay, they cannot be totally a stranger lah, basically. Okay, that's the first keyword. Good, relations. Can we move on? Okay, what's the second keywords? Anyone? What's the second keyword? Important element. I mean, very important one. All words are important here, but the much more important. Christina or any other person want to try?
Dominate.
Yes, correct. Okay, the second keyword, okay, dominate. There must be the act of domination, okay, by one party over the other. Okay, they are related, and then the one of them, okay, dominate. All right. I mean that's the keyword, the second keyword. Good. Okay. Can we have another try from who else? Badrina, perhaps. Badrina or Khairunisa or Hanis? Anyone?
Obtain.
Aha. The third keyword, there are 4 altogether actually. The most important one. All are important, but then we want to focus or zoom to the most important one. The third one. Awang.
Can you hear me, madam?
Speak louder, speak louder. Now we have the dominate, kan? Okay, the first one, relations, and then we have dominate. Okay, that's the word lah we want to focus on. Okay, the third one. Anyone?
Madam, is it unfair?
Madam?
Unfair, that one later, before that.
Okay.
Unfair is correct, but that's the fourth one. The fourth one, sorry, fourth. The third one was the third one.
Is it the will, madam?
No, no, no.
Is it position?
No.
Uses, madam.
Yeah, correct. Uses. There must be uses. Use. Okay, actual use lah. I mean the use. I mean the party really use that dominant position. Okay, good. Okay, good. Try. Okay, we go back to the slides. Okay. Stop share. I reshare the screen. Okay, we were here. Okay, thanks for all the participation. Okay, so now I put the queries queue here. What are the keywords? So these are all the keywords here. Okay, you can see there are 4 keywords lah altogether. Okay, we started just now with relations, and then we also identify the word dominate, and then uses, and then unfair advantage. So all the 4 keywords here actually it makes the important principle or the rule relating to undue influence. But again, actually, most of the time, our Contracts Act, the provisions, the essence of it, in substance, it is based on English law position. So that explains why we are looking at the approach under common law as well as all the cases at common law as well. Of course, we have all the local cases to support or to show application. But the main, the rule which is taken, which is derived, usually it is based on landmark cases from common law. Okay, we go to the next slides. Okay, before we go to another part of the discussion, okay, we want to know the reason behind, why the law bothers, to set aside, why the need, why there is a need here, why the need to set aside transaction or contract because of undue influence, what's the reason behind it? And the main reason, there could be 1 to 3 reasons here, objective here, but one of the main important one, the most important one is to prevent victimization, of whom? Of one party by the other. Meaning that here, if the party, both of them, they don't stand on equal footing, so most of the time, one of them will dominate the other. So the weaker one, the one who is being dominated, they will become the victim. Okay, mean that here, if they enter into the contract, maybe it's not what they wish for. It's not their really independent decision. Okay, that's why the law will step in to prevent victimization. Okay, so that's the word, victimization of one party by the other. And of course, the law won't help, okay? And not because of one's folly, foolishness, or imprudence, or lacks of, or one of foresight. Mean that here, maybe the weaker one here, they are not really under undue influence, but they made a wrong decision that, or maybe not really wise decision, and they regret about it later. Okay, so in that particular position, the law won't assist. You cannot really set aside, the victim cannot set aside the contract under the plea of undue influence. So the only reason the law will help or the law will step in is to prevent victimization, and not because of the party's fault or because of the party foolishness in making a good decision, in order to enter into the contract. All right, so that's basically the reason behind it. I mean, we want to know why we need to discuss about this topic. Okay? So this is the reason behind it, or the objective, okay, of the rule or principle. So from the picture, you can see them. Okay, usually it will affect elderly people, kan, because they cannot really think like normal people. It depends on the situation. Okay, or maybe we'll see, okay, who could be affected with undue influence. Okay, now we go to the classification or categories or types here. Of course, if you reread again section 16, okay, 16.1, section 2, section 3, it doesn't say, it doesn't tell, oh, there are 2 categories. It doesn't tell. Okay, how do we know? So from case law, which cases? From common law cases. Okay, so this is the approach under common law, and generally we do follow the similar approach. So we have actual undue influence. We also have presumed undue influence. I mean that here in some situation, undue influence really took place in reality, actually, very, very clear cut, very, very obvious, but in very, very rare situation. Normally, most of the time, okay, the party, the victim, the claimant or the plaintiff will prove his case under presumed undue influence. I mean that here the court or the parties just presume there was undue influence or the party was under undue influence, because it's very hard to prove it really happened. So if we go back to our earlier topic for coercion, usually it is something which is physical in nature. If you remember Nuri Asya, kan, okay, when the party signed the guarantee, he was being sandwiched by the man. I mean that here something which you can see, oh, coercion took place. But for undue influence, because it really is about pressure, how do you prove it? Okay, very, very hard to prove it happened. That's why the court, most of the time the case would fall under presume rather than actual. For coercion, we don't have actual or presume. I mean, it must happen. Okay, there and then. Okay. This classification, how do we know? This is taken from this case, House of Lords decision. In the case of Barclays Bank PLC, okay, Public Limited Company, and O'Brien and another, especially the judgment or the quotation by Lord Brown Wilkinson. Okay, all right, now we are going to look at actual first and then later presume. Actual, just a simple or short discussion, because we don't have many cases, and the parties usually they don't bring the case under actual, but they will bring it under presume undue influence. Okay, what is actual undue influence? Okay, there are elements to be fulfilled under actual undue influence. In actual undue influence, okay, the wrongdoer, the one who dominates, most of the time they are in the position of the defendant. But sometimes they are also the plaintiff. But then the plea of undue influence was raised by way of defense. So we cannot say, is it by plaintiff, is it by defendant? But most of the time it is by plaintiff. But sometimes it is also by the defendant. So in actual undue influence, okay, the wrongdoer, we use the word wrongdoer here, okay, the one who dominates. Okay, the wrongdoer expressly, that's the word. There must be express, okay, expressly uses, that's the word, okay, expressly uses the influence that he has, okay, on the complainant, okay, on the weaker party, for the purpose of obtaining the transaction. Okay, it doesn't matter whether it is a gift or it is a normal contract, because a gift usually it is one way. Okay, the party that we have the word donor, donee. The donor give the donee, and the donee doesn't give anything in return. That's the gift. But for contract, it is usually bilateral. I mean, A gives something to B and B gives something in return to A. Okay, A give subject matter or whatever things here to B. B give money, okay, to pay for the price of the subject matter. So that's the contract. So what's the thing that complainant must prove here? 2 things here. The first one, okay, the wrongdoer, okay, must be in the dominant position, okay, in his relationship. Okay, remember the word relations, okay, in his relationship with the complainant. Mean that here there must be certain relationship, and then one of them, okay, especially the wrongdoer, was in the dominant position. If they are on equal footing, there's no issue of undue influence from the very beginning. Okay, that's the first one. Usually very, very easy to prove. Okay, the first one. The second one, very hard to prove. Okay, the complainant must prove that the wrongdoer used, okay, or exerted, that's the word, okay, used or exerted undue influence on him, okay, to enter into the particular impugn, okay, challenge transaction, okay, which is very, very hard to prove. How do you prove that? Because most of the time, influence is something that you feel. And most of the time, the party doesn't realize it. Only later, maybe somebody said, hey, you were under influence. Then only he rethink, oh, I was under influence, maybe. Okay. So most of the time, the party doesn't realize it. But if you realize it from the very beginning, so maybe the case should be brought under actual rather than presumed. Okay, and do we follow this particular classification despite the fact that it's not contained in section 16? Generally, yes, we do. So how do we know? From case law. So from the quotation, case statement by Visu Sinadura judgment, okay, by him in the case of polygram records, Senam Berhad and the search. We are going to discuss this case thoroughly later, okay? But now we zoom to the judgment. We have 10 minutes left, okay? We zoom to the part of the statement or judgment, okay? Quotation by Visu Sinadura here, the judge, the justice. He said that once the complainant proved that the wrongdoer used that dominant position to obtain the transaction, okay, so now the complainant has the right to have the transaction set aside. I mean, we don't have to honor the transaction, okay? So regardless, it doesn't matter, okay, whether it was fair or unfair to the complainant. So you don't bother whether fair or unfair. I mean that here, fair or unfair is not element for actual undue influence, okay? And this is one of the landmark cases for actual undue influence. We don't have many, and this is very, very important case for actual undue influence. Very, very old case, but the rule still stands until today. Okay, still good law. So the case is Morley and Lonan, 1893. So it's 19th century case. So we have two cases. I mean, we have two parties here. Who was the plaintiff? Morley. So Morley was, when the case was brought to the court, okay, he was a deceased already. Okay, and here the representative brought the case for him on his behalf. He was, I mean, when during his lifetime, okay, when he was alive, he was a member of a religious group. And who was the defendant here? Lonan. Who was Lonan here? Defendant was also a member of the same religious group. So they belong to the same religious group. Okay. And obviously, because Morley is now the deceased, so this is the suit, okay, the action taken by the deceased executors, okay, the one who execute the will or whatever property belonging to the deceased. And during his lifetime, what happened was that Morley was actually a rich man. Okay, so he made a series of gifts, not one, okay, 1, 2, 3 gifts, series of gifts, and the total amount was 140,000 pounds sterling. Those days in 19th century, very, very huge amount. Even now, this is quite still a big amount. Okay, and he gave it away to Lonan. And they are not family lah, obviously here. Okay. And what happened was that Morley here, during his lifetime, he was under Lonan religious influence. Okay? Why is that so? Because he had lived in Lonan's house, okay, in great seclusion. So cannot mingle around, okay, just stay there. For how many years? Very, very long here. For the last 7 years of his life. I mean that before he died, okay, 7 years before he died. So he actually stayed with Lonan in his house, basically. So now the executors wanted to get back all the property. Okay, it shouldn't be given to Lonan at the first place. Okay, that's what they argued in the court. So the deceased executors claimed to recover, okay, to get back the huge sum here, okay, 140,000 here. And then yes, they succeeded. They won the case. Why is that so? What's the reason? Okay, because the deceased already died, cannot really testify, cannot really tell, oh, I was under influence whatsoever. Okay, how do we prove the case? Okay, but they managed to prove the case. They managed to convince the court. Yes, Morley was under undue influence by Lonan. Okay, in this case, the important part is that, okay, executors were able, okay, to prove that Morley, during his lifetime, Morley realized actually he was under influence here. Okay, Morley had expressed to a neighbor during his lifetime. Okay, he said to the neighbor, okay, Lonan family and his family, okay, not one person lah, his family have ruined his life. I mean, his life is ruined, and that they had taken away all his property. So when he gave away, actually, it was against his wish lah. It's not independent act, okay, by Morley here. So when he said so, okay, by way of expression here, very, very express sayings here, okay. So this established his state of mind. Okay, when he give away, okay, when he made the gift, he gave the money away unwillingly. There's no free consent. Remember, okay, whatever contract, it must be done with free consent. And here, it was done without his free consent. Okay, we cannot prove the case under coercion because there's no element of coercion at all here. He's just being influenced here. Okay, pressure, something which is improper on him. All right. And then the court made the decision. I mean, this is the judgment by the court, okay, the observation by the court. The money, okay, 140,000 pounds sterling was obtained, okay, by the exercise and abuse of personal influence and ascendancy. Okay, that's the word, okay, ascendance. So domination, okay, established under. So now what kind of pressure here? A cover of religion and religious brotherhood. I think those days, kind, most part of the world, they are very religious lah. Nowadays quite liberal kan. I mean, it affects all the religions actually. Okay. So now improper pressure here, it refers to religious brotherhood under the cover of religion. So whatever gift made by Molly here, it was not the result of the deceased's own free will. Okay, he doesn't give away his property actually, but it was done. Okay, and it was the effects of influence and domination by Lorna over Molly the deceased. So this is the case of actual undue influence. Okay, remember, okay, on the part of the evidence here, okay, so I believe, okay, the neighbor was one of the eyewitness lah. Okay, that's why I mean the court give judgment in favor of the executors. Okay, can prove very convincingly, okay, by way of evidence. Remember, evidence can come in documentary evidence, okay, oral evidence, by way of testimony lah, okay, by oral witness, okay, by eyewitness, okay, could be oral evidence. So this is the case of Molly and Lonan. I'm not sure how many time left. Oh, we have 4 minutes left. Okay, so again, now we want to sum up, okay, to summarize it. So for actual undue influence, okay, actually there's no need to show existence of special relationship. Okay, we just prove there could be some relationship between the parties. Okay, but the most important part, the key element is to prove actual, that an influence, I mean undue influence really happened, really took place, okay? Even though the complainant has not suffered any unfairness or disadvantage. It doesn't matter whether does it affect the property or the position of Molly here. The court won't, won't bother. I mean, it won't affect the decision of the court. Okay, it could be unfair. It could be, I mean, it doesn't really affect. Maybe Molly here doesn't have any kids or any family, that's why he gives away the property. So it's not really unfair to him, for example. But the court won't look at that particular factor. Okay, the court will just see, was there any actual undue influence that took place when the transaction was entered by the parties here. Okay, that's actual undue influence. Okay, now before we end our session for today, okay, the question to everyone: what is the position in reality? In reality, is it easy? I mean, is it practical, okay, to prove the case under actual undue influence? So in reality, most of the time, it is difficult to produce evidence. But Molly and Lorna is one of the exceptional cases. That's why it's landmark case. Okay. So in majority of reported cases, okay, successful plaintiff, those who are successful in their action, okay, they had relied on presumed undue influence rather than actual undue influence, because it's very hard to produce evidence. Most of the time, the party doesn't know he was under undue influence. Okay, and it's very hard to prove. All right, that's why the case will proceed under presume. We'll assume, oh, there was undue influence because of these circumstances, for example. So the case will be argued under presumed undue influence rather than actual. But Molly and Lorna is one of the exceptional cases which was successful, basically. Okay, I think we have to stop here because presumed undue influence is a long discussion. Okay, because it has elements, and then both elements must be proved extensively lah, basically. So I stop share. Stop.